Former President Donald Trump is on trial in New York in a $250 million civil lawsuit that could destroy the personal fortune and real estate empire that helped propel Trump to the White House. Trump, his sons Eric Trump and Donald Trump Jr., and executives of the Trump Organization are accused by New York Attorney General Letitia James of participating in a decades-long scheme in which they used numerous acts of fraud and false statements to inflate the Trump's net worth to obtain more favorable loan terms. The trial comes after the judge in the case ruled in a partial summary judgment that Trump had submitted fraudulent appraisals of his assets, leaving the trial to determine further actions and what penalty, if any, the defendants should receive. The court adjourned for today, and the trial will resume on Monday for the start of the defense case. The courthouse will be closed Friday for Veterans Day. Donald Trump Jr. will return to the stand to testify as the defense's first witness on Monday, assuming the judge does not rule in favor of Trump's motion for a verdict to dismiss the case early. Judge Engoron rejected a motion by New York's Attorney General to bar 4 experts from testifying on behalf of the defense when it presents its case starting Monday. The state had attempted to prevent the testimony of the 4 experts on the basis that, following the testimony of the state witnesses, the 4 defense witnesses were no longer relevant to the case. "You won the battle. We'll see if you win the war," Engoron told defense attorney Chris Casey, even as he warned him that he would cut off witnesses if they attempted to discuss established facts. In issuing his ruling, Engoron reiterated the conclusion drawn from his previous summary judgment order that Donald Trump made at least 10 internally contradictory statements in his financial statements. "You can't make a correct statement with these kinds of errors," Engoron said. Casey told the court that Donald Trump Jr. will be the first witness to testify in the defense case on Monday. "Oh, I know him," Engoron deadpanned after the announcement. It will mark Trump Jr.'s return to the stand after the state put him in the dock last week. The hearing resumed after the lunch break, and Trump's lawyer, Chris Casey, appeared to have changed his mind about his earlier comment directed at State Attorney Andrew Amer. Before lunch, Casey threw some shade at Amer during arguments on the state's motion to bar the testimony of 4 defense experts. Upon returning from court after the break, Casey recanted his words and apologized. "I will apologize to the court. I will apologize to Mr. Amer," Casey said. "I appreciate it and accept the apology," Amer responded. Trump attorney Chris Casey was visibly frustrated as today's proceedings focused on the state's motion to exclude testimony from 4 defense experts that the state claims are no longer relevant to the case. After State Attorney Andrew Amer spoke in favor of the motion, Casey suggested that it belongs to totalitarian Russia. "I suggest Mr. Amer check the internet," Casey said. "Vladimir Putin has some opportunities. This is where he belongs." Describing the comment as completely unnecessary, Judge Engoron suggested Casey apologize to Amer. "I have no intention of apologizing," Casey said, although he promised to refrain from further derogatory comments. Judge Arthur Engoron did not immediately rule on the defense's motion for a directed verdict to end the trial early. Instead, the judge simply said that the arguments had been considered. In concluding his argument for a directed verdict, defense attorney Chris Casey channeled some of his client's rhetoric, praising Donald Trump for helping the community and reshaping the New York skyline. "What building did the Attorney General build in this community?" Casey asked. State's Attorney Kevin Wallace, arguing against the defense's motion for a verdict to end the trial early, reiterated that the state's case is based on documents that they say incriminate Donald Trump and his adult children. "This is a records case," Wallace said. Each of the 3 defendants signed documents in which he stated that he was responsible for the correct filing of the statements. While all of the defendants testified that they relied on accountants, Wallace said by analogy, it is as if the defense were to say that using an accountant absolves an individual of filing false tax returns. I am responsible for that fraud, Wallace said. I am not exempt from my responsibility because I entrusted it to an accountant. Clifford Robert, the lawyer for Eric Trump and Donald Trump Jr., argued that his clients were caught up in a political dispute between the lawyer and their father, and that the fraud case should be dismissed as part of the defense. A motion for judgment directed to dismiss the case. The evidence clearly shows that my client was not really involved in the preparation of the statement of financial position, said Robert, referring to the suspected fraudulent documents that were among trial attorney in New York. To prove his point, Robert pointed to the testimony of 6 witnesses who testified that Eric Trump and Donald Trump Jr. not involved in the preparation of their father's financial statements. Trump's lawyer Chris Keyes, arguing for the expected decision to dismiss the case, said the state relied on testimony from former Trump lawyer Michael Cohen to try to prove that Trump was involved in the conspiracy, scheming to defraud lenders, but they were ruined by Cohen's inconsistent testimony. Effort. Cohen testified that Trump spoke like a leader of the people when he asked Cohen and Alan Weisselberg, the former chief financial officer of the Trump Organization, to release his financial statements without saying so. He's not a guy who talks in code, Kesey said, adding that you'll know what he wants within minutes of talking to Trump. Justice Arthur Engoron responded to Kesey by citing what Trump called a perfect call in 2019 with Ukrainian President Volodymyr Zelensky, which became the basis for Trump's first impeachment, as an example of Trump speaking in code. Kesey said the only other evidence that there was a conspiracy to defraud lenders came from the young president of the Trump Organization, who said Alan Weisselberg told him, Mr. Trump wants, as the amount of his money and the state of his financial situation increase. Trump's lawyers argued that his testimony should be inadmissible because it is hearsay. Even if that happened, that statement alone is not proof of agreement, Kesey said. The Attorney General's office, in response to the defense's request for a decision to be directed, because the state did not prove that the bank or insurance company reported fraud from the Trump Organization, admitted that none of its witnesses were directly rejected. During the trial, whether they would have loaned the Trump Organization if they had known about the fraud investigation the New York AG alleged. The banker said, "We should have done something different. If so, who?" Judge Engoron asked the state prosecutors. "Mr. Hay said that in his documents," Attorney Kevin Wallace replied, referring to Nicholas Hay of Deutsche Bank, although Wallace acknowledged that Hay was not questioned during his investigation. Defense attorney Christopher Keyes, in his argument for the proposed decision, said that the state did not provide any evidence that banks or insurance companies would treat the Trump Organization differently. There is no argument, not even a rule of thumb, that the approval, rate or conditions would be different, Keyes said. At the end of the day, what matters is the decision-making process of the bank. If they deliberately support it, then it doesn't matter. Keyes also said that the inclusion of the so-called no-value statement in Trump's financial statement, which warned the lenders that the analysis in the document required judgments, that they should do their own analysis, showed that Trump has no purpose. Fraud. This prompted Engoron to intervene. "It's like when you say that someone says, 'Don't believe me.' It means they're not lying," Engoron said. The former president's defense team sought a summary judgment in the case, arguing that New York Attorney General Letitia James did not meet the evidentiary standard necessary to prosecute the case. The Attorney General's approval applies only to successful and profitable loan transactions, argued defense attorney Christopher Keyes. Nobody was involved. There were no complaints. There were no injuries. Judge Arthur Engeron has ruled in a preliminary indictment that Trump committed fraud by deceiving banks and insurance companies into granting him a favorable loan based on financial statements that understated his assets and inflated his net worth, him leaving the case to determine what else to do and what rights, if any, the defendants should receive. The defense argued that the state did not provide evidence that the bank or insurance company made a complaint of fraud, or that Trump did not fulfill his financial obligations. There is no intent to deceive, no defects, no damage, no unfair advantage, and no victims, Kise said. There is no evidence that anything would have been different in a loan transaction or an insurance transaction. Defense attorney Jesus Suarez asked. Ivanka Trump during cross-examination yesterday about what Deutsche Bank executives said after receiving Trump's money to renovate the Doral Golf Club in Miami. Ivanka Trump replied, "They are very happy." Kise said of banks, if they think someone is cheating them, they don't do business with them. For more news like this across the globe, please subscribe to our channel, like and share this video. Thank you.